We're going to cut into that package now to go live to Illovo, where the OUTA conference is taking place.
They had decided that the public consultation conducted by SANRAL before GFIP commenced in 2008 had been adequate, which it clearly hadn't, and failed to consider and decide on further reasons put forward in the review why e-tolling was unlawful at all. OUTA and its co-applicants appealed to the Supreme Court of Appeal. OUTA and its co-applicants did so on the firm belief, shared by many, that the introduction and planned implementation of e-tolling by SANRAL was unlawful, unconstitutional, and amongst other reasons, because firstly, SANRAL had clearly failed to conduct a meaningful public and participation process before it decided to declare Gauteng's freeways toll roads. The 3 million or so motorists in Gauteng and the road-using public were not properly informed of SANRAL's plans, nor given the opportunity to participate in the decision at all, as is required by the SANRAL Act. Secondly, the Minister of Transport failed to properly consider the exorbitant costs of e-tolling that would be borne by the public when approving SANRAL's plans to declare Gauteng's freeways toll roads. The very person who had to safeguard the public from an overly expensive scheme did not properly consider the expense of the collection process. Thirdly, the enforcement of e-tolling would be practically impossible because of the sheer numbers of users of the GFIP. Gauteng's courts and law enforcement system will be unable to deal with the thousands of expected defaulters per month. OUTA and its co-appellants also appealed because they believed that on the levying and collection of an e-toll as a scheme that had not been introduced according to law. It would violate the constitutional rights of the road users not to arbitrarily deprive them of their property. Astoundingly, the SCA in its judgment responded by refusing to consider and decide on the unlawfulness of e-tolling. Instead, the SCA decided the appeal largely on the technical basis that there had been too long a delay in challenging the e-toll. The property challenge was also dealt with on the basis and it was defeated on the delay argument. In short, the SCA has said it is too late, and it has closed its eyes to the fact that e-tolling may be unlawful. Before commencing briefly on the finding of the SCA concerning delay, it is necessary to clarify what the technical approach adopted by the Supreme Court of Appeal in its judgment means. It means, firstly, that OUTA, the appellants, and road users still have no clarity on the lawfulness of e-tolling. The merits have not been decided on, and in this regard, the SCA said that it was, and I quote, barred from embarking on the merits. Here I must pause to state that the recent statements issued by SANRAL and government that the SCA judgment affirmed SANRAL had consulted adequately is clearly inaccurate. You only have to ask almost any road user in Gauteng who will tell you that this was not the case. It means, secondly, and very importantly for every member of the public, that it remains open to any citizen to lawfully decide not to pay e-tolls and defend his or her prosecution for failure to pay e-tolls on the basis that the toll declarations and the approval by the Minister of Transport of e-tolling was unlawful. This is called a collateral challenge, in which the delay matter, which is a legal obstacle in the review, is totally irrelevant. This, we must stress, is a very positive implication of the SCA judgment for the rights of individuals. Despite this, it must nevertheless be said that we are bitterly disappointed that the SCA adopted to take the course it did. OUTA and its co-appellants have looked to the courts to protect their members and the road-using public from the unlawful action of SANRAL and the government, and the courts have thus far failed them. This disappointment and the effect of the failure of the courts to come to the assistance of the road-using public is and will be felt most acutely by persons with low income and by the members of the Quad Para Association of South Africa, abbreviated as QASA, who effectively only receive a 1,200 Rand grant to live on, and who cannot be exempted from e-tolls because they rely on the generosity of others to transport them, who will in turn become reluctant to assist them getting around. In regard to delay, it is a startling feature of the Supreme Court of Appeal's judgment whereby OUTA is advised that a solid ground for an appeal exists, in that considering whether to condone the delay, the SCA totally ignored the fact that QASA instituted proceedings in its own right and on behalf of its members, and it was undisputed that QASA only came to know about e-tolling in February 2011. The Supreme Court of Appeal was wrong in not granting QASA condonation on the delay and then dealing with the merits. How could members of QASA be blamed for the delay between SANRAL and the government's decision to e-toll and the launch of the proceedings when they were unaware of e-tolling? By the same token, how could the public be blamed for the same delay when they likewise were prevented from knowing about SANRAL and government's decisions to e-toll in 2008, following the failure of SANRAL to properly inform the public during the formal public participation process? The public at large only became aware about e-tolling after the World Cup in late 2010 with the emergence of the e-toll gantries. The SCA failed to confront this fact. Its findings by the SCA that the public knew or ought to have known about e-tolling already some 2 or 3 years before February 2011, being its starting point in finding that there was an inexcusable delay in bringing proceedings, is vague. It is unsupported and provides further grounds for appeal. Indeed, why is it that we find ourselves in a situation today where there is an overwhelming rejection by the public, if indeed society was properly and meaningfully engaged with? But what does the SCA judgment and all of the above mean for OUTA? Well, OUTA has a couple of avenues open to it. As regards to further litigation, chief amongst these is that OUTA could take this matter to the Constitutional Court to make a decisive ruling on the unlawfulness of e-tolling. OUTA is advised that it has solid grounds for this appeal. But OUTA here will be confronted by a shortage of funds. OUTA has been transparent with the public in this regard at all times, and it will remain so. Despite overwhelming contributions made by society to raise 90% of OUTA's required funds, we still remain around 1.5 million rand short. We have been advised that a further appeal will be around another 1.5 million rand if we were going to take this to the Constitutional Court. If OUTA does not raise these funds, it will be unable to proceed with the appeal. OUTA could alternatively cease to continue with further litigation and allow its case thus far to provide the grounds for a collateral challenge by one of its members, or indeed any motorist who is prosecuted for non-payment of e-tolls, and furthermore it continues to support the public in its opposition to SANRAL and the government's unlawful e-tolling scheme outside of the courts. OUTA must now carefully consider its options and determine its next course of action. In this regard, OUTA will have a board meeting on Monday next week to consider its position and make decisions on its way forward. In regard to legal costs, OUTA, together with its co-applicants, are of course very pleased at the Supreme Court of Appeal's decision to set aside the costs order made by the North Gauteng High Court. The SCA clearly realized that OUTA is indeed a broad-based apolitical organization acting in the interest of the public and representing many road users within society. The decision follows and confirms the rule that applicants in the public interest and the constitutional litigation should not bear costs if unsuccessful, a rule so important for constitutional democracy and for the keeping in check of unlawful and unconstitutional government action. Before closing and moving for a moment beyond the SCA judgment, it is necessary that OUTA highlights the following for all who may listen or want to read this statement. Firstly, OUTA and its co-applicants are not standing isolated or in a minority in their campaign against e-tolling. OUTA's opposition to e-tolling as a funding mechanism for GFIP is shared by all political parties, barring the ANC. It is shared by substantial union representation through COSATU, through the South African Local Government Association, through the ANC Youth League, and businesses represented by the Black Management Forum, Business Unity South Africa, known as BUSA, and the JCCI, which is the Joburg Chamber of Commerce and Industry, to name but a few. OUTA's stance has also recently been boosted loudly and clearly by the moral authority of numerous faith-based organizations, not to mention the hundreds of thousands of citizens who have expressed their outrage at SANRAL and government's ETOL plan. Government's recent comments that belittle the extent of the opposition to e-tolling reflects just how out of touch they are with the people on this issue. The groundswell of common opposition to e-tolling that stretches across political, socio-economic and religious divides defines itself and finds itself in the precedent only that one could see in the apartheid days and those unjust policies that were caused by them at the time. And yet SANRAL and the government refuses to listen to the face of such reaction by society and to an unjust policy. Secondly, the exorbitant costs of e-tolling must not be forgotten in the face of the SCA judgment that dwelt on the delay matter. SANRAL and government have spoken proudly about their comfort to pay 17% towards the e-toll collection costs, as if this in itself is an acceptable level. But to make matters worse, they conveniently disregard the violations processing centre, which adds a further 8.7% to those costs, and another 2.4% towards operational expenses. By OUTA's account, the costs of e-tolling collection and administration is well over 30%. And this has recently been corroborated by public statements made by CUPS Trafficcom in Europe, who claimed that they will directly benefit to the extent of over 50 million euros, or the equivalent of 670 million rand per annum from Gauteng's e-tolls, a cost which in itself equates to 24% of SANRAL's 71 billion rand figure of e-toll revenues generated over 24 years. Thirdly, a unique and almost unprecedented feature about the opposition to e-tolling has been the willingness for society to pay for the upgrades, while insisting that preferred funding models need to be as efficient as possible. The court papers clearly highlight that SANRAL merely applied a cursory glance at the opportunity to use the fuel levy fund to fund the Gauteng freeway upgrade. Indeed, responses to a parliamentary question by the Democratic Alliance in May this year, Minister Martins revealed that the fuel levy was not considered at all by the government to pay for the Gauteng freeway improvement project when the decision was taken in 2008. OUTA, like millions of other citizens, remain unconvinced by both SANRAL and government's relentless objections to the consideration of a fuel levy as a funding mechanism, which is already a policy tool available to government for road funding infrastructure. Recent media comments by SANRAL and the government to try and undermine the fuel levy option merely highlights their narrow train of thought and unwillingness to engage objectively on this highly efficient and equitable user pays funding option. To suggest that we seek to fund the entire GFIR project from 1 year's fuel levies is simply ludicrous. Furthermore, it is important to note that e-tolling is in fact an owner pays mechanism rather than a user pays system, which gives rise to numerous administrative challenges and onerous time-consuming implications to the road user and the vehicle owners alike.
Wayne Duvenage, chairperson of the Opposition for Urban Tolling Alliance, there holding a press conference in Illovo, speaking about being bitterly disappointed about the Supreme Court of Appeal's decision yesterday, having decided against OUTA's decision to bring that application to halt.
News that moves. ENCA.com.